Evidence for the 2024 Illinois Bar Exam. The federal rules of evidence apply in civil, criminal, and bankruptcy proceedings. There are some common areas that are tested where the federal rules of evidence do not apply. They do not apply to the grand jury, and they don't apply to sentencing and probation. One other category to which the FRE does not apply are preliminary hearings. What do we mean by that? Bail hearings, hearings to obtain a warrant, preliminary hearings to admit evidence, contempt hearings, or on the outside, extradition. Okay, so the FRE does not apply to grand jury. That's right. What are the other two? Sentencing and probation. That's right. And preliminary hearings of what type? Hearings that's right, admit evidence, bail and warrant hearings, any preliminary criminal hearings, contempt, and extradition. Most commonly tested, grand jury, sentencing, and probation. All right, let's talk about preserving a claim of error for appeal. FRE 103 states that if the ruling admits evidence, the attorney must timely object on the record or move to strike and state specific grounds. If evidence is going to be admitted, what must the attorney do? We don't want that evidence in, right? We're going to, that's right, object on the what? The record, or move to, that's right, strike that evidence. And what do we have to state? Grounds, always. Objection, grounds. If the ruling admits evidence, we do what? One sentence. Timely object on the record or move to strike and state specific grounds. What happens if you do not object, attorney, on your evidentiary ruling? That will be plain error affecting the defendant's substantial rights. So that is prejudicial but reversible. Okay. Can the court take notice of plain errors on its own? Yes. Plain error affecting a defendant's substantial rights could be harmless, meaning there's no prejudice to the defendant, or it could affect the outcome. So in other words, the most commonly tested scenario is the ruling admits evidence, the attorney must, that's right, timely object on the record or move to strike stating specific grounds. And if there's no objection, it's considered plain error. What about if the ruling excludes evidence? Then the attorney must make an offer of proof. Admits, object, move to strike, state grounds. It excludes, make an offer of proof. If there's no prejudice to the defendant, it's harmless error. And do we ever need to renew our objections to evidence or offers of proof for the same evidence? No, you never need to renew an objection. Looking at preliminary questions. FRE 104A, the court decides preliminary questions about whether a witness is qualified, a privilege exists, or evidence is admissible. The court is not bound by the rules of evidence except those on privilege. Repeat, the court decides, that's right, preliminary questions about whether a witness is qualified, a privilege exists, or evidence is admissible. And the court is not bound by the rules of evidence except those on, that's right, privilege, FRE 104A. Relevance that depends on a fact or conditional relevance. When the relevance of evidence depends on whether a fact exists, proof must be introduced, sufficient to support a finding that the fact does exist. Repeat, if the evidence depends on a fact, when the relevance of evidence depends on a fact, whether a fact exists, proof must be introduced, sufficient to support a finding that the fact does exist. And can the court just admit the evidence? Yes, on condition that, that's right, the proof be introduced later. What's the standard? whether a reasonable jury would accept it as true. Conditional relevance, or relevance that depends on a fact. Repeat after me. When the relevance of evidence depends on whether a fact exists, proof must be introduced sufficient to support a finding that the fact does exist. The court may admit the proposed evidence on the condition that the proof be introduced later. Preliminary questions. Is the court going to conduct preliminary questions where the jury can hear it? A court must conduct any hearing on a preliminary question so the jury cannot hear it. Repeat, the court must conduct any hearing on a preliminary question so the jury cannot hear it if it regards admissibility of a confession, or a criminal defendant takes the stand as a witness and requests that the jury be excluded. At a preliminary hearing, the court has to conduct any hearing on one of those preliminary questions so that the jury cannot hear it. Admissibility of a confession, and if a criminal defendant will take the stand on a preliminary issue. At a preliminary hearing, can the defendant be cross-examined? Not on any other issues when they're testifying on a preliminary question. Does a criminal defendant waive their Fifth Amendment privilege by testifying at a preliminary hearing? No, they do not. All right, preliminary questions. The court must conduct any hearing on a preliminary question so the jury cannot hear it. FRE 104C, including, the admissibility of a confession, or B, when a criminal defendant will take the stand as a witness and requests that the jury be excluded. Criminal defendants don't waive their Fifth Amendment rights by testifying. And FRE 104 also provides that if the court admits evidence that is admissible against one but not against another party, what do? That's right, they restrict the scope and instruct the jury accordingly. FRE 104 is also restricting the scope. If the court admits evidence that it is admissible against one but not against another party, or for one purpose but not for another purpose, the court must do what? They issue a limiting instruction, restrict the evidence to its proper scope, and instruct the jury accordingly. Plain English. The judge will issue a limiting instruction if they admit evidence for one purpose but not for another, or for against one party but not another. They are going to give a limiting instruction to the jury, telling them restrict the evidence to its proper scope. Moving on to FRE 106, the rule of, completeness. If a party introduces all or part of a writing or recorded statement, what happens? That's right, the adverse party may require the introduction of any other part that in fairness ought to be considered at the same time. If a party introduces all or part of a recorded statement, the adverse party may require the introduction at that time of any other part that in fairness ought to be considered at the same time. FRE 106, the rule of completeness. Part of a writing or recorded statement is introduced, the AP may request the rest of it or another part of it, if in fairness it ought to be considered at the same time. Okay, let's talk about judicial notice. FRE 201. The court may take judicial notice on its own or on motion. What's our legal standard? The court may judicially notice a fact that is not subject to reasonable dispute, generally known within the court's jurisdiction, or accurately and readily determined from a source whose accuracy cannot be reasonably questioned. 3 prongs. Judicial notice. on motion or on its own, at any stage, the court may judicially notice a fact that is, that's right, not subject to reasonable dispute. 2, generally known within the court's jurisdiction. Or 3, accurately and readily determined from sources whose accuracy cannot reasonably be questioned. Okay, we discussed restricting the scope with a limiting instruction. When the judge issues a limiting instruction in a civil trial, the court must instruct the jury to accept the noticed fact as true. Criminal trial, the court must instruct the jury that it may or may not accept the fact as true, innocent until proven guilty. So judicial notice, jury instruction, restricting the scope. Civil, court must instruct the jury to accept the noticed fact as true. Criminal, court must instruct the jury that it may or may not accept the fact as true. That's the difference. Innocent until proven guilty for a criminal jury. Let's talk burdens of proof and shifting the burden of proof. Okay, we know this. Beyond a reasonable doubt, criminal. Preponderance, civil. Who bears the burden? The plaintiff or the prosecution. What about clear and convincing evidence? So to prove something by clear and convincing evidence, that is criminally related civil actions like fraud, validity of a will by deed, and the defendant has the burden. Okay, so but our basics are beyond a reasonable doubt, criminal, preponderance, civil, and things like the validity of a will, it's clear and convincing. And who has the burden? The defendant. The defendant has the burden of proof in all affirmative defenses. Okay, but how do we shift that burden of proof? Presumptions. So, for example, if there's a rebuttable presumption that, for instance, someone who has a conviction for domestic violence is not a fit parent, that party has the burden to produce evidence to rebut the presumption. This doesn't shift the original burden of persuasion. So if you're trying to take away someone's parental rights, for example, there's a rebuttable presumption in that state that a person convicted of domestic violence is an unfit parent. It is the accused person's duty or burden to rebut the presumption, but it doesn't shift the original burden of persuasion. So if it's rebutted, what happens to that presumption? That's right, it disappears. But what if the defendant doesn't rebut that presumption? It's considered true. Think back to corporate law. There's a rebuttable presumption that the directors are acting in good faith and with the best interests of the corporation in mind. That's our business judgment rule. And what do we need to overcome that presumption? A showing by the defendant corporation of good faith. Okay, so presumptions. Do we ever have presumptions in criminal cases? No, because you cannot presume someone guilty. So in my domestic violence example, that's a civil matter. It's family law. In our corporations example, that's a civil matter, but never in a criminal case. There are no presumptions, rebuttable or otherwise, in a criminal case. FRE 301. All right. Always, 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 always address relevance in an essay. Evidence, FRE 401, you know it. Evidence is relevant if it has, that's right, any tendency to make a fact more or less probable than it would be without the evidence. And 2, that's right, the fact is of consequence in determining the action. FRE 401, prong 1, evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence. And prong 2, the fact is of consequence in determining the action. Relevant evidence is admissible unless what? It goes against the Constitution, federal law, or a Supreme Court rule. Irrelevant evidence is, of course, never admissible. FRE 403, remember our 401, 403 balancing test. Evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. Balanced with 403, the court may exclude relevant evidence if its probative value is substantially outweighed by a danger of, that's right, unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, needlessly presenting cumulative evidence. 401, evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. Balanced by 403, the court may exclude relevant evidence if its probative value is substantially outweighed by a danger of unfair prejudice. And our other prongs here, confusing the issues, misleading the jury, undue delay, wasting time, needlessly presenting cumulative evidence. But probative value versus prejudice is our basic balancing test. All right, moving on to character evidence, FRE 404, character evidence. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion that person acted in accordance with that character or trait. Okay, remember this used to be a little bit simpler. Evidence of a person's character is inadmissible to prove conduct in conformity therewith. FRE 404 now reads, evidence of a person's character or character trait is not admissible to prove that on a particular occasion that person acted in accordance with the character or trait. Character evidence, character trait, not admissible to prove somebody acted that way on a specific occasion. All right, how can we prove someone's character? Reputation or opinion on direct, specific instances only on cross. Reputation or opinion only on direct. What's your opinion of the defendant, sir? Oh, he's a peaceful guy. On cross. Isn't it true that he attacked your wife last year? Reputation or opinion, specific instances only on cross. Can you impeach a witness for character? Yes, you can. And there's no limit on how you can impeach the witness on any matter that pertains to their credibility. Okay. The only exception is, of course, if it is a collateral matter. You can't use extrinsic evidence to impeach a witness if it's a collateral matter. So in other words, if we ask the witness, what's your opinion of the defendant's truthfulness? Well, he's a truthful guy. Well, didn't you know he cheated on his taxes last year? No, I didn't. You're stuck with the answer. You can't bring the IRS. There is one exception, and that is if character is an essential element. In other words, defamation, then you can use specific instances of conduct. So character at issue is our exception. All right, going back, proving character on direct, reputation or opinion. On cross, specific instances of conduct. Impeaching a witness, if it's a collateral matter, no extrinsic. What if character is at issue? Then you can use specific instances of conduct. Remember, defamation, negligent entrustment. What's a defense to defamation? Truth. What's a defense to negligent entrustment? Well, I'm not sure, but we'll get there later. Okay, so that is for civil. For criminal cases, we do have exceptions. The criminal defendant can open the door. The criminal defendant can offer evidence of the defendant's pertinent trait. And if they do so, they open the door and the prosecutor can offer evidence to rebut it. So in other words, the prosecutor in a criminal case may never offer criminal defendant's character evidence. The prosecutor may never comment on criminal defendant's character. But the criminal defendant may offer evidence of his own pertinent trait. And if so, that opens the door for the prosecution to rebut and offer evidence of the defendant's trait. Okay, so first exception, criminal defendant can open the door by offering evidence of their own pertinent trait. I'm a peaceful guy. Opens the door to the prosecution. Okay, now they get to offer their own character evidence that the defendant is not peaceful. All right, next, the criminal defendant may offer evidence of the victim's pertinent trait. And if this, of course, opens the door for the prosecution. What can they do? They can rebut the evidence that the victim had some sort of pertinent trait, and two, offer evidence that the defendant has the same trait. Example, the criminal defendant can say the victim is known as for starting fights. The prosecutor can offer evidence to rebut that the victim is known for starting fights. And they can say, criminal defendant, isn't it true that you have a character for starting fights? Okay, homicide only. The prosecutor can offer rebuttal evidence of the victim's trait for peacefulness if the defense alleges the victim was the first aggressor. Okay, so any criminal defendant can offer evidence of the victim's pertinent trait. That opens the door. Prosecution can rebut and offer evidence of the defendant's same trait. If it's homicide and the defendant suggests the victim was the first aggressor, the prosecutor may offer evidence of the alleged victim's trait of peacefulness. Okay, civil. Criminal defendant can offer defendant's own trait, opens the door for the prosecution to rebut. Criminal defendant offers evidence of the victim's pertinent trait. Prosecutor can offer evidence to rebut the victim's trait and offer defendant's same trait. And if homicide, the prosecutor may offer evidence of the victim's trait of peacefulness to rebut evidence that the victim was the first aggressor. Okay, sorry, those are all criminal exceptions. Okay, moving on to other crimes and other bad acts. First of all, if we're going to offer other crimes into evidence, what does the prosecution have to do? They have to notify the defense in writing that they're going to offer this. In Illinois, this is called a Montgomery motion. All right, so other crimes, other bad acts are inadmissible to prove that on a particular occasion, the person acted in accordance with that character. Hey, he did the crime once, he did the same crime this time. He beat up that girl once, he beat her up this time. Inadmissible to prove that on a particular occasion, the person acted in accordance with that character. But it is permissible for the mimic exceptions to show motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. All right, other crimes and other bad acts. Are they admissible to prove character and conformity? No. Other crimes and other bad acts are inadmissible to prove that on a particular occasion, the person acted in accordance with that character, the character of a violent person or the character of an armed robber. But it is permissible for the mimic exceptions: motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Let's repeat that. Motive, next is opportunity, third is intent, fourth is preparation, fifth is plan, sixth is knowledge, 7 is identity, 8 is absence of mistake, and 9, lack of accident. Other crimes, other bad acts, inadmissible to prove character and conformity, admissible for motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, lack of accident. Okay, other convictions. So we just looked at other crimes or other bad acts. Other convictions. What are we talking about? A felony conviction. In other words, something punishable by death or imprisonment of greater than 1 year. Crimen falsi, theft, forgery, false pretenses, embezzlement, always coming in, always coming in. The judge has no discretion. Crimes involving dishonesty or false statement are always admissible no matter how old they are. You are convicted of theft, forgery, embezzlement, false pretenses, larceny by trick, crimen falsi, always coming in, no matter how old. Judge must admit crimes involving dishonesty or false statement. What about those other felonies? They have to be less than 10 years old from date of, that's right, conviction or release from, that's right, confinement, whichever is earlier. So other felonies have to follow the 10-year rule. Less than 10 years old from date of conviction or release from confinement. Okay, there's a standard here. We can admit convictions against defendants or witnesses who aren't the defendant. Let's say we're impeaching a witness with their criminal conviction. The prosecutor has to show only that the probative value outweighs prejudice. It's less than 10 years old. It's a witness. It's not the defendant. Probative value outweighs prejudice. What if the prosecutor is seeking to admit a criminal conviction against the defendant? The prosecutor must show the probative value substantially outweighs the prejudicial effect to that defendant. Okay, let's go over that again. We are impeaching a witness with their criminal conviction. Not the defendant. The prosecutor must show the probative value outweighs prejudice. Criminal defendant. The prosecutor must show the probative value of the conviction substantially outweighs its prejudicial effect. And what do we have to do? Always, we must notify the adverse party. We're going to notify the defense. Other crimes, other bad acts, other convictions. The prosecution must notify the defendant in writing. Okay, crimen falsi, admissible or not? Always admissible. How about felonies? Only admissible if less than 10 years from date of conviction or release from confinement. Civil cases follow the general rule. Criminal convictions for a witness who's not the defendant, just a regular old witness. To impeach that witness, the prosecutor has to show, that's right, probative value outweighs prejudice. What about if the witness is the defendant himself? The prosecutor must show the probative value of the crime substantially outweighs its prejudicial effect to the defendant. And what do we always have to do? Notify them in writing. Notify the defense in writing. Okay, moving on to victims of sex offenses. Okay, to offer any evidence of the victim's sexual behavior or predisposition. Generally, the victim's sexual behavior or predisposition is inadmissible to show the victim engaged in other sexual behavior. Inadmissible, the Rape Shield law. Victim's sexual behavior or predisposition is inadmissible to show the victim engaged in other sexual behavior. In a criminal case, you can only introduce instances of the victim's sexual behavior to prove that someone else besides the defendant was the source of physical evidence or to prove consent. So, in general, The victim's sexual behavior or predisposition is inadmissible to show the victim engaged in other sexual behavior. If it's a criminal case, you can use specific instances of victim's sexual behavior to show that someone other than the defendant was the source of physical evidence or consent. Okay, so in a civil, so in other words, stalking, no contact. Criminal, it would be rape. Civil, it would be stalking, no contact. Can we talk about the victim's reputation? Well, no. You can talk about the victim's reputation only if the victim placed her reputation in controversy and its probative value substantially outweighs the danger of harm to any victim or unfair prejudice to any party. In a civil case, stalking, no contact, can we put the victim's reputation in controversy? Only if the victim did it herself, said, I have a character for chastity, or I never would have consented to this. I want to remain a virgin until marriage. So if the victim places her sexual reputation in controversy, then the defense can bring that up only if, that's right, the probative value substantially outweighs the danger of, that's right, harm to any victim and unfair prejudice to any party. All right. In a civil case, evidence that a party committed any other sexual assault or molested any kid, that's coming in against them. So if there are any, so when we're talking about victims, we're protecting them. The victim's sexual behavior or predisposition is generally inadmissible to show the victim engaged in other sexual behavior. If it's criminal, we can bring up specific instances, but only to show the defendant somebody else was the source of the physical evidence or to prove consent. We can only bring up the victim's reputation in a civil case if she placed it in controversy and the probative value substantially outweighs the danger of harm to any victim or unfair prejudice to any party. But guess what, sex offenders? If you have committed any other sex offense or molested any kid, that's coming in against you. Evidence that a party committed any other sexual assault or child molestation is coming in against that defendant. Okay, moving on to public policy exclusions. There are some things that we exclude based on public policy. They are compromise negotiations, plea bargains, civil or criminal, subsequent remedial measures, offers to pay medical expenses, and evidence of liability insurance. All right, let's go through these one by one. Okay, our public policy exception number 1, compromise negotiations. Can't be used to prove the validity of a claim or the amount of a claim. We want to encourage people to compromise. So we cannot use it to prove whether a claim is valid or the dollar amount. We cannot use evidence of compromise or settlement negotiations to impeach by prior inconsistent statement or by contradiction. Hey, didn't you say in those settlement negotiations that you would accept $50,000? No, you can't use evidence of compromise negotiations to prove or disprove the validity or the amount of a disputed claim or to impeach. Only way that you can do that is to show witness bias or prejudice when you're impeaching them. Okay, number 1, evidence of compromise negotiations can't be used to prove or disprove that's right, validity or to the amount of a claim. And it cannot be used to impeach, but it may be used to show the witness was biased or prejudiced. Okay, number 2, FRE 408, plea bargains. We talked about compromise negotiations. Obviously, that's some sort of civil settlement. But what about plea bargains? What's inadmissible? That's right, a guilty plea that was later withdrawn, a plea of nolo contendere, and plea discussions with the prosecutor. not the police. What's inadmissible? Guilty plea later withdrawn, plea of no contest, plea discussions with the prosecutor, not admissible. Remember, whatever you say to the police can and will be used against you. If no guilty plea resulted, we don't discuss plea discussions with the prosecutor. Inadmissible, 1, guilty plea later withdrawn. 2, plea of no contest. 3, plea discussions with the prosecutor if there wasn't a guilty plea. How about plea discussions with the police? Try not to talk to the police. Okay. When is evidence of a plea bargain admissible against the defendant? Perjury or false statement. If the defendant made the statement under oath, on the record, and with counsel present. The defendant's committing perjury, under oath, on the record, with counsel present. Do you think that's admissible against them? Yes. All right, subsequent remedial measures are inadmissible to prove negligence, fault, a product or design defect, or need for a warning or instruction. When does this come up? In strict liability, products liability, in tort. Okay, so we have a products liability case. Subsequent remedial measures on the part of the manufacturer is inadmissible to prove that they were negligent, at fault, that there was a product or design defect, or a warning or instruction was needed. Okay, when are subsequent remedial measures inadmissible? To prove negligence, fault, product or design defect, or the need for a warning or instruction. When can you admit subsequent remedial measures? Well, you can impeach with them, but it's the big exception is ownership, control, and feasibility of precautionary measures. So subsequent remedial measures, you fixed that door, didn't you? You can use that to prove that the person owned the store or was under control of the automobile. You can use it to impeach them. All right, how about offers to pay medical expenses? Can you use those to prove someone was liable? No. Offers to pay medical expenses are inadmissible to prove liability. What about liability insurance or lack of it? Inadmissible to prove negligence or wrongful conduct. You can use it to show agency ownership or control, but not that they were negligent or they did something wrong. We want people to have liability insurance. So we can bring it up to prove that they had agency, ownership, or control, but we can't use it to prove negligence or wrongful conduct. Okay, and that is part 1 of 2024 evidence for the Illinois Bar.